Mr. Strauss.
Thank you, Andrew, Ruben, all of the co-sponsors, my fellow panelists, and all of you for sharing part of your day with us. This panel was inspired by the upcoming trial of Khalid Sheikh Mohammed and others, and so I'll tend to focus on that. My comments are going to be informed by three guiding principles. First is, it's more important to prevent terrorist attacks. The question of how you do that is more important than the question of what court you use to prosecute people who have already committed them, especially when you have available options. The second, American values are important, but there are competing American values that need to be balanced in all of this. And third, reality is more important than symbolism. Trying this group in civilian court is pure symbolism, and the reality is really does a disservice to the rest of us. So, let me say that I'm going to be really focused on KSM. I'm not, others may speak more broadly about the philosopher king questions of whether we should use civilian courts or use use military tribunals or what. I want us to just deal with the problem at hand. And on that, this decision is truly a man-caused disaster on national security grounds, propaganda grounds, and public safety grounds. Let me start with national security. The trial will give people who are trying to kill us valuable counterintelligence. And disclosure in court and in the media helps Al-Qaeda learn about our intelligence tactics, methods, and sources. And these people may be twisted, but they're not stupid. They've learned a lot of things in past trials, and they've acted on them. Now, based on existing Supreme Court cases, it's not always clear what constitutional rights apply to aliens. But it is clear that when you try them in civilian courts, they receive enlarged protections, many of which will impair our ability to protect intelligence. Now, the important thing for you to understand, and others will disagree, but there's an inherent tension, conflict, incoherence of trying to reconcile Brady rights, classified information under CIPA, and the right of self-representation. Civilian defendants have Brady rights, and that means that the government has an obligation to provide evidence in its possession, or which it can reasonably get, that would be exculpatory with respect to either guilt or punishment. Civilian defendants also have a right to refuse a lawyer and to represent themselves, and the Supreme Court has held that that's absolute. Possibly it can be forfeited. I'll make it a side point here. Court dockets are public, and when terrorists represent themselves, the names of their filings can be unusual. In the Zacharias Moussaoui case, here's one of them. Emergency strike by slave of Allah Mujahid Zacharias Moussaoui to counter dirty insider dealing by Fat Megalo Dunham for his chief pay persecution master Ashcroft, aka United Satan Chief Liar, and to have Fat Megalo out of 9/11 circus trial. Now we smile, but our national security people had to take that seriously and ask themselves whether that was code for something, and then try to spend time trying to crack it. But back on point, the right of self-representation could mean that sensitive information, not always top secret, but sensitive, useful information goes directly to the defendants. They're surely going to demand information about our tactics and methods. They'll want testimony from people who interrogated them and the people who interrogated the government's other witnesses. They'll want testimony from officials who developed the counterterrorism strategy. If they don't get it, there may be grounds to challenge convictions. Now, this is supposedly all dealt with by something referred to as CIPA, the Classified Information Procedures Act, which was actually designed to deal with another threat that was designed in the Cold War era to protect classified information. And it has some legs. Pieces of it have been enacted in the 2009 MCA Act. But it was not designed with the threat of global terrorism in mind. Under CIPA, evidence will be revealed and admitted if the judge decides it's discoverable and relevant. The defendant will get access to it. And what typically happens is that defense counsel with security clearances will be involved in a SEPA hearing, pre-trial, if you're still dealing with those issues by the time you're in the pre-trial stage. And the court will determine what's admissible without compromising security, and does it give a fair presentation of all the information. What about the terrorist who represents himself? He can never be in that SEPA hearing. The stage is set for challenges and objections. And this is important. Under SEPA, all appeals have to be heard before the trial can take place. So this thing can delay trials for years. And also, SEPA, by its name, only applies to classified information. There's a lot of information that's not classified, but is damn useful. And there's, I know Jim may have something to say about this, because I've heard him say it, but in the 1993 World Trade Center bombing, prosecutors produced a list of unindicted co-conspirators. It was a guidebook to American intelligence. It was turned over to bin Laden in Sudan within days of when it was produced. He could see that, for one, he was on the list. He could also see who else was and why, and figure out how we got it. Poor man's teleprompter. By using civilian courts, we're giving away a lot of things we don't need to. And that's why the so-called successes of past civilian cases are illusory. We'll spend just a little time on Dr. Reyes Moussaoui now. We can spend a lot more time later if anyone is interested, because it's a fascinating story. But he was the so-called 20th hijacker. Despite very capable prosecutors, this was a prolonged mess. He was indicted in 2001, December. He was sentenced 5 years later, went to the Fourth Circuit 3 times. The Fourth Circuit just handed down the post-sentencing appeal this month, and he pled guilty. If he hadn't pled guilty, we still wouldn't have tried him. Moussaoui's representation was convoluted. He wanted to represent himself. He refused court-appointed defense counsel with security clearances. He wanted to consult with, but not be represented by, Muslim attorneys who did not have security clearances. Finally, Judge Brinkema ruled that he forfeited his right based on a couple of things. His repeated outbursts in court, and second, filing pleadings with titles like, Judge Leone Brinkema, that begins, "Leone, you bitch. The ZM must get the wicked tyrant Congress 9/11 report." She revoked his pro se status and appointed standby counsel, and there's a whole host of fascinating issues that triggered. The case really put a focus on the inconsistency that I'm trying to get you to focus on, and it leaves open questions. What happens with Brady rights and SEPA in a trial in which a defendant both represents himself and behaves, or in a guilty plea in a different context? I will finish up the other 2 points much more quickly. The next part of this disaster is that it gives KSM a grand stage in the media capital of the world to broadcast propaganda. That's going to embolden and inspire current terrorists and probably a future generation of terrorists. You know, the defense will be to put the government on trial. Here, the funny thing is, it means the Bush administration. Now, I don't want to be partisan, but it is a relevant fact. It is relevant that elements of the current administration want to hound, attack, and punish the past administration for policies they disagree with. The KSM trial could very easily be a show trial just for that, that would appease that base to some extent. Some commentators say that's the only rational, feasible reason for doing it. I don't go that far. I say that this is an old maxim. You should not ascribe to design that which can be adequately explained by incompetence. But if the trial is for the benefit of that base, I know the Fordham ACLU is a co-sponsor today, and I thank you for that. The ACLU has an important role to play in our society. It's just not to be in charge of national security. final piece of this disaster is that the trial will impose enormous additional security risk and economic burdens on the city, which is already overexposed and overburdened. It'll be a public safety nightmare, a flashpoint, extra motivation for attacks. On my way over, a friend sent me Mayor Bloomberg's current word. Apparently he spoke to the press a couple hours ago. He thinks it would be great if it were moved. He's along with Community Board 1, is of the theory that they're not fighting the commissions versus civilian trial fight. They just want it out of New York. Hold a civilian trial on a military base. Hold it at West Point. Anyway, the community, the local citizens, ground zero, they voted. Their board voted 42-0 in favor of approaching Holder to get a change. And Mayor Bloomberg said it would be great if that happened. The tragic part of all this is that it's all self-inflicted. You know, the military commissions, we can talk about those, others will. All I'll say is that in their current form, they've been approved by Congress, the courts, and even the Obama administration for other terrorists. And something can be done about this, by the way, apart from moving it. Hopefully we'll talk more about this in the, later. But the district courts are, pardon me, inferior tribunals under the Constitution created by Congress. Congress created them. Congress can set their jurisdiction. It can strip jurisdiction over KSM in a single sentence act. And I do hope we'll talk about that. But now I'm over time, so thank you for your attention.
Thank you, Mr. Vitkowsky.